Okay, welcome everyone. Welcome to our webinar this evening on alternative dispute resolution. We're talking about different mechanisms for resolving different disputes within the workplace. My name is Jesse Todd. I am a regional representative in the Saskatoon Regional Office. With me on the call today, we have Louise Mardell, who's also a regional rep in the Saskatoon Regional Office. We also have Keith Gauthier, who's also a admin person and who works in the Regina Regional Office. And we also have Caroline Klug, who's the education officer working out of the Winnipeg Regional Office. So I thank them very much for their help behind the scenes today. They're the ones that are going to be answering questions and helping you through the process. So I'd like to just refer you to the toolbar that should be on the side of your screen. There's different functions on there. There's different functions you can submit questions, whether it's technical issues or other issues related to this webinar. There's also a chat function, which we will use as far as going through some of the different interactive features of this webinar. So please ensure that your audio and visual is working. Just make sure that if you are having any sort of technical difficulties with audio, it may quit intermittently. Sometimes there are glitches within the program. Usually the best fix is to use the just log out, and log back in. If you're continuing to experience technical difficulties, please give Keith a call. His cell phone number is 306-501-1402. And that is also for people that are experiencing or maybe have logged in through their phones. If you're not on a computer, if you just called in through the 1-800 number. If you want to text a question to Keith, you can also text him through the same number, 306-501-1402. And we do have moderators that are looking at the question boxes throughout the evening. So if you do have questions about the content, technical issues and such, please don't hesitate to use those functions to ask your questions. So this evening we're talking about our alternative dispute resolution. Have you ever wondered if there is another way to resolve a workplace issue besides a formal grievance? So tonight we're going to talk about maybe learning about those situations, how they may benefit from conflict resolution, understand the steps that need to be taken and who needs to be involved for the best outcomes. So our objectives this evening will be to understand alternative dispute resolution mechanisms, what that is, to understand the process for ADR, to understand when it's appropriate to use this mechanism, and also to understand what the benefits of using ADR. So this evening we'll have three guests joining us our webinar. First we'll have Cheryl Wilson Robinson, and also Pam Sahota and Jackie Oswald. They'll be giving their perspectives from their different experience through this process. And they have varied experience, so that hopefully we can benefit from their experience. And there's going to be opportunities throughout this webinar to participate. You can ask questions. There's going to be some poll questions, and it'll allow you to be more interactive. But before we get any further, I'd like to introduce Marianne Ledoux. For those who don't know, Marianne Ledoux is our Regional Executive Vice President. And welcome, Marianne.
Great, thank you. Give me a wave if you can hear me okay. Perfect, thank you. It seems as the weeks go on, I seem to be killing headsets. So I'm never quite sure, but I just got a new one delivered this morning. So, you know, good timing. So, you know, again, I want to thank the staff. We've been doing these webinars since end of March. We started off doing them as health and safety webinars because that was the immediate priority. And because we're not able to do education in the region, we can't, you know, bring you into a boardroom at the office and do some of this. You know, the staff, every office is kind of grabbed onto a topic and taken a week. And, you know, we have, I think this is our 12th webinar. And it's been just a wide variety of topics. So, you know, thank you to the staff that are on screen and those that are helping in the back. You know, on On ADR, this is something that, departments sometimes advocate for, employers advocate for it. And it's something that can be complicated. Uh, you know, employers may want to do ADR to avoid grievances. But I think, I'm really interested in this topic because I've been out of the grievance world for a little bit. Um, but sometimes strategically we want to file a grievance because we want that on record, or there's um, a bigger issue that we want to make sure that it's recorded that we're opposed to as a union. But ultimately, at the end of the day, we want resolution for our members. And if there's a process whereby we can do it with ADR without filing a grievance, and the member is made whole and everything is resolved, then it's to everyone's benefit. So I'm really looking forward to hearing the presentations. And on that note, I'll just say thank you. And if there are questions later, although I suspect on this topic I won't be able to answer many questions when we've got experts on the line. So I'll just say, thank you to the presenters who are coming up, and I'll be sticking around if there is any questions I can answer. Thanks.
Thanks, Marianne. So I guess before we get into the kind of the whole presentation, we really need to frame this discussion, because mediation can be used at any stage throughout the grievance process. This is something that we can use to, we may recognize that maybe mediation or some sort of ADR process is actually beneficial to the member, because it may not be something that's specific to the collective agreement. And that's something we'll get into in further detail later on in this presentation. But it's also important to note that this does not replace the grievance process. And like Marianne said, we don't want to have this replace grievances. We don't want to, because sometimes we do want to have it on record, especially if we are getting into bargaining. If there hasn't been a grievance filed, there hasn't been a grievance recorded, the employer may at some point say, well, if this is such a big issue, how come we haven't heard about it? So that's where we want to make sure that we do have those grievances in place. But there are points throughout time, and I've actually experienced myself where I've had a member of ours when I was a shop steward come up to me and say, well, I want to file a grievance because this manager is being so difficult. They're not, approving leave or whatever the case may be. And you have a manager that's threatening to file, they want to discipline this member because this manager thinks that this member is being, unreasonable. And then you sit down with the member or the manager and you say, well, have you guys actually talked about it? And they're both like, well, no. And so that's where we have to say, well, maybe we need to actually sit down and discuss this issue before we actually proceed into maybe a formal grievance process. It may just be a complete understanding. This day and age, especially working from home, we're in the situation where we're sending emails more and more rather than having those face-to-face conversations. So you can't read somebody's body language, and an email can be misinterpreted so easily, as I'm sure many people on this call have experienced before. So this is really a mechanism that can help resolve a lot of those issues. So I think next we're going to get into a poll question. So what is the objective of alternative dispute resolution? First, you have a multiple choice options here. The first is to prove your right. The second is to avoid the grievance process. The third is to find a mutually beneficial outcome to the dispute. And the fourth is to allow me to yell at my manager. So I'm going to give everyone about 30 seconds to enter their responses, and then we will review them as a group.
So Jesse, we have about 83% of the participants who have voted.
Okay, we have about 10 seconds left, and then we'll see if we can close the poll. Okay, so seeing no further responses, I suppose we can close it now. So it looks like we're all in agreement. Everyone has agreed that it's to find a mutually beneficial outcome to a dispute. And that's absolutely correct. We're not in there to prove we are right. You both may be right. You may just be kind of somewhere in the middle. And we don't want to avoid the grievance process if it is necessary. Absolutely, we want to make sure if there's been a clear violation of the collective agreement that we want to ensure that we are pursuing grievances. And yelling at your manager, well, that's absolutely not the point of ADR. We want to make sure that we are respectful through this process. So next slide, please, Louise. Oh, sorry, we just have another poll that came up. I guess we can do this right now. Grievance mediation is appropriate for any dispute situation, true or false? Well, it looks like we're pretty steady here. Everyone's entered their votes. So we have here, let's close this. Sorry about that, folks. We had 70% of the people saying it was false. Or sorry, we just had a quick change at the end. It was 68 that said it was false and 32% saying it was true. This is not actually appropriate for any situation. We are obviously if there's a clear violation of the collective agreement, we don't want to enter into any sort of mediation, like Marianne had said, and I echo to that as well. If there's a clear violation of the collective agreements, we want to ensure that those are being recorded, so the employer is fully aware. We don't want that being stuck at a maybe a low level manager level where people have, or the upper management, maybe depending on where you work, a Western area director can't just say, well, I didn't know about it. So we're just going to go through the basic tenets of ADR before we get into our first guest. So we want to talk about who is involved. Well, it's obviously the individuals are involved in the dispute. It's also important to note this process is entirely voluntary. So I can't say to Louise, who's on the call, working in the background, I can't say, well, I want to drag Louise into this process and have it out with her and duke it out. That's not going to happen. She has to agree to attend those meetings as well. And also throughout this process, if I feel that it's not working for me, if I feel that it's one-sided or the other party is just not engaged, you can actually decide that I'm done with this process at any time. And actually, you also have the option to return to that process. You can jump back into it and put that grievance in abeyance and say, well, actually, I think mediation might be the best outcome for both of us. Maybe new information comes to light, that sort of thing. So the facilitation of communication between the parties involved in a dispute to work constructively with them in a flexible, creative way to assist in reaching a resolution. So what does that mean? We really want to ensure that people are given all opportunities to express themselves through this process. So the people that are assigned to these files are professionals. They have experience in dealing with it. They've got many different ways to help facilitate communication. So it's not just going to be two people sitting across the table kind of scowling at each other saying, how they've been done wrong by the other person. So that's definitely different ways of getting to the root of what the core issue is. And the where is, well, it can be determined by the two parties. Sometimes, like I've witnessed it where it's been, people are fine using one like the small meeting room in one of their offices. Obviously, during the COVID times, that might not be an option. So maybe a large boardroom, and maybe through virtual means these days. So it's one of those things that is comfortable for both parties. So the when. Mediation can be used at any stage during the grievance process. So again, you may come to that point where you have been given new information through the grievance process and you're like, well, I didn't know that. I didn't know where this person was coming from making these decisions. Maybe we should just put this in abeyance, put this on pause, and maybe go through the mediation process. As long as both parties are, agreeable to that, then it could be a positive route forward. And again, this does not prevent you from using the grievance process or another form of process where one exists. So whether it's harassment or those types of things. So this does not prevent you from pursuing those avenues. And again, you can switch between mediation and the formal process at any time. Why? Well, the purpose is to reach that mutually beneficial resolution. That's what we talked about in that one poll question. So really, the mediator, again, is a professional. They're going to get you to realistically evaluate your position and also what your expectations are coming out of this. So that way we can actually look at different avenues to settle these issues. There's not always a right and wrong way to do it. It's kind of meandering through those gray areas. So the purpose of mediation is not to determine who is right or wrong, and we talked about that in the first poll question. So we're shifting that focus from maybe how you were done wrong or why you've been angry with this person in the past, but we really want to focus on what are the future resolutions. How can you actually still go forward with this person in the workplace? So next, I'd like to introduce Cheryl Robinson Wilson. So Cheryl Robinson Wilson has worked as a grievance and adjudication officer in PSAC's representation section since 2001. She works out of the PSAC Toronto Regional Office. As a grievance and adjudication officer, she has represented PSAC at adjudication and arbitration hearings in the litigation of grievances, and she has represented the union and its members in matters before the Public Service, our Labor Relations Board, and the Canadian Industrial Relations Board. She has also been involved in the analysis and referrals of grievances to adjudication and arbitration. Since 2007, Cheryl's work has primarily focused on mediation, as she has worked in the capacity of Alternative Dispute Resolution Office, representing PSAC members at mediation hearings and helping members negotiate the settlement of their grievances as an alternative to going to adjudication or arbitration. So I'd like to welcome Cheryl.
Cheryl has just sent a note. She's just logging on, so she'll just be a few moments.
So many of you may not be aware that we have people in Cheryl's position, and actually something that Louise and I were, pleasantly surprised. They have shifted people from the adjudication officer position to this position, and it's a good to have people within the PSAC structure that actually can assist with these situations, because as reps, we don't always have the tools and have the experience at hand to help address these issues. So it's definitely a benefit to us to be able to draw on people with Cheryl's experience. So is Caroline, do you know if Cheryl's still having issues logging on?
Okay, so Cheryl's indicated that she can't show her video, but let's try to unmute her and hopefully we'll be able to hear from her.
Okay.
And I'm going to check in the attendees and hope she's there.
I see her, that she is.
Okay. And
Cheryl, can you hear us? Hi.
I can hear you. Can you hear me?
We can hear you, yes.
I'm so sorry. I don't understand why I'm not able to turn on my webcam. I was before, and then I joined again as a panelist, and now I can't. Like I had the option of joining before, so I'm not sure what's going on. So sorry about that.
The joys of live webinars.
Live webinars. So I'm just going to go ahead and talk. I'm
Sure.
sorry that you can't see me, but Happy to be here, and thank you very much. I was able to follow along for the most part in the beginning until I had to switch over as a panelist. So thank you very much for having me. You're absolutely right. We do have 3 designated officers in the representation section of the PSAC who do mediation, and that's their job full time. So they're alternative dispute resolution officers, and I am one of them. The 2 of them working out of Ottawa, and I work out of the Toronto office. So yes, ADR is it's a new and sexy term. It's a very on vogue thing lately to try and work things out alternatively. But I think it's a very important piece of the work that we do to represent members at PSAC. I was very interested to hear that Marianne said that she said it's important to file grievances, and I agree. So the mediation that I do, the alternative dispute resolution that I'm involved with on a day-to-day basis in my work, always has to do with grievances that have been filed, and then we are stepping outside of the process of the road to either arbitration or adjudication to try and see if we can mediate a resolution for matters. So that's what I do every day, and that's the kind of work that I'm committed to, and PSAC is committed to try and see if we can help our members. Now I'm just launching into sort of my little dialogue here. I didn't know if there was if that's what I'm supposed to be doing, or should I carry on?
Sure. Yeah, we were just talking about, I guess, can you introduce kind of the basic concept of ADR, and maybe also go into when is it appropriate to go the ADR route?
Right. Okay. So you've already touched on some of the basic concepts already. So ADR, or mediation, which is the type of ADR that I do, is basically, as has been said, it's an alternative way to resolve a problem or a grievance if you're at the level where a grievance has already been filed. And so, as I said, it's a way to avoid carrying a case forward to go to adjudication or arbitration, where the resolution is decided by a decision maker, an arbitrator or adjudicator. It's basically a process of discussion. And when I work with members who are going to mediation with me, I say, really, it's about having a discussion with your employer. And often people say, well, I've had many. I've done level 1, level 2, level 3. I've had many discussions. Even before I filed the grievance, I tried to have the discussion. But there's something very different about when the parties sit down together with the purpose of trying to avoid going to adjudication or arbitration, and wanting to be part of the resolution, wanting to resolve it. So I think the concept of a neutral party helping and assisting the parties to facilitate a discussion, having both parties being willing and volunteering to sit down with the other, not to yell at each other, but to sit down and really listen and to consider each other's point of view, and finding a way to arrive at a resolution that can work for both parties. Doesn't mean you get everything you want for either side, but you can work with something that at the end of the day you can walk away feeling I'm satisfied with that. So that's the basic concept. It's really a discussion in a way to find a resolution to a dispute. And in my case, as I said, to find an alternative to going to adjudication or arbitration. So it's interesting because in my work, it's like what's appropriate to do to go the ADR route. It's not always appropriate. It doesn't work in every case, absolutely. But I find that as long as you have parties that are willing to sit down together and figure out a resolution, you might be surprised the kind of cases that you can resolve through ADR. You can resolve disciplinary cases where, for example, the parties have agree that, there was discipline that was merited, but maybe the discipline was too extreme or too severe. There can be discussions where the employee can sit down with the employer in a mediation context, share their experience as to what was going on behind the scenes, what happened behind the scenes, or vice versa. You could have the employer sitting down and sharing what was going on behind their decision to take the action that they did. Somewhere in that discussion, and again, a mediated, facilitated discussion by an expert, not only who's a professional in doing mediation, but a professional in labor relations, right, can sit down with the parties and sort of help them see the other's point of view. Maybe not see eye to eye, but see their point of view. So I believe that if you've got that, you know, a lot of different grievances that you might not think would be possible to resolve can be. Now, I think earlier it was said that, you know, there are those files where there's been a violation of the collective agreement, and it might not be appropriate to go forward because we want a decision from a neutral body that says, you know, the collective agreement should be interpreted as X or Y, and either the union's position is the correct interpretation or the employer's position is the correct interpretation. So in those types of cases, you know, it's not really ideal to try and mediate a resolution. But I find in my work and the work that I've been doing with my colleagues, you know, often files like duty to accommodate, sometimes harassment and discrimination, grievances that may have some sort of interest on either side, either party, the employer or the union or the griever, like the griever specifically, may have some desire to avoid the publicity of the facts surrounding the grievance, because often when you go to adjudication, when you go to arbitration, that's a public decision. It's a decision that's written and recorded and out there for people to see. So sometimes there are sensitive issues that the parties would prefer to deal with the matter, have the conversation, not necessarily have all that out there in the public. So that might be appropriate to sit down and see if you can find a resolution. There are grievances where discipline has been meted and perhaps it's been sunsetted, i.e. it's been more than 2 years and the collective agreement provides that the discipline goes away after 2 years, or the grievers have changed their position on what they want as a remedy. These are all sorts of situations where conversations and discussions and sharing of perspectives might actually find a way to resolve the matter without having to take it forward to an adjudication. So sometimes there's negotiation involved, but the key thing to come back to is it's the sharing of perspectives. And to me, that's the most important piece. You have people who want to be there, people who want to listen when they're listening to the other side, sharing their perspective. And that way you can actually come to you can find your way to a resolution. You can find your way to understand each other's side and maybe not get everything you wanted in the beginning, but you'll find a way to live with what you can resolve together as the parties. So I think it's, you know, there's no exact answer when it's appropriate. You have to have those key elements of voluntariness, of willingness, of parties that are willing to listen. And I think it's very important to have a professional, neutral mediator to help you.
That's great. Thanks, Cheryl. So just one last thing. We have a couple minutes left, but could you give an example of how the ADR process unfolded with the mediation you were involved in?
Sure. And I'm going to give you a very bright and recent example, fresh from off the presses, so to speak. It was last week. So it was different because it was virtual. And this is something that's new, obviously, in light of COVID. The board is opening up to that concept, obviously, out of necessity. So it was a grievance that, and this goes to show where there is discussion amongst the parties during the grievance process. And even after the grievance had been filed and almost at adjudication, the parties could agree on one way to resolve this matter, but we were stuck. So essentially, it was a member who, to make it very simple and quick, she needed accommodation to work closer to where she lived. And there was a bunch of different complications that came to the situation because she used to in the past and had no issues driving to and from far distances to get to her workplace. And as you can imagine, the employer's position was, it's not our job to accommodate you, whether you live 2 hours away, an hour away, half an hour away, 5 minutes away. This is the job. If you agree to do the job, you get yourself to and from work. And she had a back issue that impacted her ability to drive the long distance to where her work was. So she did all the right things. She tried to look out for transfers, put feelers out, spoke to her manager, was able to get some different term positions that were closer to where she lived to assist. But at the end of the day, her substantive was a 2-hour drive away. And with her back issues, she wasn't able to do that. So we had some agreement that basically they wanted this worker back. She had been off on DI and now was ready to come back. She still had the limitations in terms of her ability to drive far distances, but they wanted to find a way to assist her, even though they felt they hadn't done anything wrong in terms of the duty to accommodate. They had accommodated her with a sit-stand desk at her workstation, but again, it was her responsibility to get to and from the office. So at the end of the day, we were able to agree, because a new position had come up fairly recently, like within the last month, that was closer to home and she could transfer into, and that was part of the sort of offer on the table to resolve her grievance. However, she still had some issues in the way she had been treated. She still had some hurt, and she had she had seen the things that were done wrong to her and sort of couldn't let go of that. So because we realized that this is a valued employee, an employee who the employer wanted to work with, they felt they did their job to accommodate them, but they wanted to work with, we agreed that we would try a video mediation session and help to have the parties be able to speak about the decisions that the employer made and why they weren't able to just plop her into jobs, for example, other priorities, other people, whether workforce adjustment or true duty to accommodate in their jobs, needed to be accommodated and put into different positions. And she needed to share about the impact of the years that she, went through looking for work and not being supported, up to and including being off on disability for 2 years and not having a soul call her to say, how are you? And she had felt forgotten. So we had a great mediation. And really, this is key, is that you had all the parties who were willing, all the parties wanted to talk to each other. She was able to express the injury, the hurt, and they were able to express the reasons why they weren't able to do some of the things they wanted to do under the proper, duty to accommodate, banner. However, they also acknowledged that they hadn't communicated well with her. They didn't express to her why she couldn't get certain jobs. So she was just left thinking, I could have had that job. I could have had this job. I couldn't have that job. And it led to the deterioration of her health and leading ultimately to 2 years off. So having that conversation facilitated, even virtually, but facilitated by a mediator, and having all the parties listen and wanting a resolution, we were able to come up with a resolution where the employer could put something on the table that acknowledged the hurt for her. And that's what she needed. And that, together with a job in a closer location, we were able to resolve the grievance. And that's a grievance that didn't, and it had, I think, 3 grievances were there that didn't have to go to adjudication. So, and she was able to get a resolution much faster than she would had she waited the number of years it would take for the board to schedule her adjudication. So that's a very fresh example. And, all the right elements were there. Again, people wanted to find a resolution. That's not always the case. Sometimes you have to sort of push the employer a little. They have to push you a little bit. But with a proper mediator, you actually can have that conversation and try to share that perspective so that you can come to a resolution at the end of the day. But again, you have to have the desire of the parties to want to be there and to want to fix it. And that's not always there. So those cases would not go to a mediation and they wouldn't be appropriate, but this one was. Sorry, I hope I haven't gone too long, but that was a fresh example that I did just last week. And we have a very happy member and a very happy employer, with a member going back into the workplace not unhappy, which was a big goal for them.
That's a fantastic example. It's thank you very much for sharing. And just for our listeners or attendees, Cheryl will be sticking around for the Q&A session in case you have further questions for her at the end of the webinar.
Absolutely. So I'll just mute myself again then, Jesse, okay?
Sure, thank you
Sorry
very
about
much.
the video. Okay,
Not
thanks.
a problem.
Okay.
So we are moving on to our next poll questions. So Caroline, can you cue it up, please? Okay, first poll question. Grievance mediation is appropriate when the parties in dispute do not have the authority to resolve the problem. True or false? Looks like the numbers are starting to stabilize. I'll give you one or a couple more seconds here to figure it out. People are second guessing some of their decisions. Okay, so yeah, we think everyone's entered their responses here. So we have 78% of the respondents have said false and 22% have said true. The correct answer would be false. So it's not always appropriate when the parties don't have the authority to resolve the problem. This may be still a grievance issue that has to be referred to the next level. This doesn't mean that it has to go straight to mediation. So yeah, I believe we have another poll question in the queue. Okay, the next question. Grievance mediation is appropriate when there is interest in maintaining or rebuilding the relationship. True or false? Give it a few more seconds here. Okay, it looks like everyone has entered their responses. So we have 96% of the respondents saying true, and then 4% saying false. The answer would be true. It is appropriate when there is interest in maintaining or rebuilding relationship. Because it is a voluntary process, not everyone is going to, if one side is not interested in maintaining that relationship, kind of, the example that Cheryl gave, then obviously we wouldn't pursue this, the ADR process. And I think we have one last poll question left. Then we'll get on to our next panelists. Grievance mediation is appropriate when the party is challenging the validity of law, policy, or collective agreement provision. True or false? Looks like there's a few more people entering their responses, so I'll just give it a few more seconds here. Okay, I think we have our responses in. So we have 89% of the respondents saying false and 11% saying true. The answer most of the time would be false because if we're going through ADR or mediation, if there's a legal issue at play, maybe a violation of policy or collective agreement provision, we would likely be pursuing some sort of complaint process, maybe the grievance process. But there is a maybe clause. I know Louise likes to use the maybe, and sometimes it may be the process forward if there is some sort of miscommunication. And I've had that happen before where people are dead set, they know that this is a clear violation of the collective agreement, but maybe the manager did not communicate things properly. But most of the time, if we are dealing with law, policy, or collective agreement provisions and the validity of those, we would be pursuing the grievance process. So we have two more panelists up on deck. So first we have Pam Sahota. And she has worked as a grievance and adjudication officer with PSAC since August of 2017. She represents members before the Federal Public Sector Labor Relations and Employment Board, as well as the various provincially constituted boards of arbitration. She is based in the Calgary Regional Office. Welcome, Pam. Next, we have Jackie Oswald. And Jackie became a federal government employee in April 1st, 1992. I don't think that was an April Fool's joke because she stuck around. She was working from the Lanigan detachment of the RCMP. She became local president in October 1993 of USJE Local 40061. She was the alternate RVP in 1998 for Saskatchewan, Manitoba RCMP Justice Public Prosecution. In 1999, she was elected as RVP in the same listed region. Jackie has been RVP since, but also from 2005 to 2011, she was the National Executive Vice President of USJE. Excuse me. Jackie has a food business called Jackie's Delicious Delights, and she's worked with different local ministries feeding those that are in need. Welcome, Jackie.
Thank you.
So we have some questions for the both of you. Let me just kind of cue them up here. So I think first we'll start with Pam. So as a GNA officer, when you first receive a case, what do you look for? Is there any sort of supporting case law? Can this be resolved by other means such as mediation? You're on mute, Pam. Sorry.
Sorry, I answered the question there. No. So the things that I look for when I get a file are what are the facts? And as you mentioned, is there any case law to support the grievance? And by that meaning, what are the chances of success? And then the next thing I look for, even if there is case law to support a possible chance of success, is can this case still be settled? Is there any way to resolve the grievance without having to proceed to an actual hearing? And even when it gets to my stage, something that I still consider is the employer and the griever, are they still maybe open to trying to mediate this? Because mediation is still an option right up until the hearing starts and even during the hearing process. So those are the sort of the main things that I look for when I get a file.
Sorry, I also take myself off mute. What are some components that make cases that you've worked on good candidates for mediation, such as is the employer willing to mediate? Is there a possibility for resolution using mediation, that sort of thing?
Yeah, so I mean, the main thing is when it gets to my level, it's often because either the employer in the initial stages didn't want to attempt mediation, or sometimes it does happen where the parties did sit down and mediate, and the mediation, for whatever reason, failed. They didn't come to an agreement, and so the grievance continued to proceed. So obviously, one of the main considerations right off the bat is the employer even willing to consider mediation? Because if they're not, then we can't force the employer to engage in mediation. But one of the things I look for when approaching the employer for mediation is sometimes we get cases that the case law doesn't really support the grievance, and if the matter proceeds to adjudication, there's a good chance that the griever is going to, or the grievance is not going to be upheld. The grievance will be denied. But there are still real outstanding issues between the employer and the griever that need to be resolved. And Cheryl gave a great example of that with the duty to accommodate case. And so that's something that's always in the back of my mind. Is there still an issue? Is this employee going back into the workplace? Do these parties still have to interact on a daily basis? If there is, then there's value in mediating, and then I will use that sort of rationale to try and get the employer to come and mediate, as opposed to just proceeding straight with the hearing.
Fantastic. Jackie, so when was the time that you recognized that it was appropriate to a situation to pursue ADR How did you introduce this idea to pursue this process, and how did you know it was a possibility for your member?
Well, I'm going to use an example of a detachment where there was many public service employees, all of the same classification, all doing the work together and the division of work, and having a new employee being told you're doing this and this and this from the other employees that have been there for a long time, and a friction happening because of that. And my suggestion of us meeting in a mediated sort of gathering and talking about the workload, because we all had the same, I could see that everyone had the same goal in mind, you know, and I know it was a simple one, talking about just your workloads, right? But with the new people coming in, getting to voice their concerns and their new ideas, you know, so knowing that everyone had a common goal made, in my mind, it a great possibility, right? So we actually sat down and discussed it all, and some new ideas actually came up from the newer employees that didn't have a chance to input before, right? So we sat down and everyone came out of it feeling absolutely great, where before there was disgruntled people because the people who had set it up originally were, for lack of a better word, PO'd because the newer people with ideas, you know, were overstepping them. And so the mediation happened, everyone came out and everyone worked cohesively together. And that's a good example of it working out and seeing a workplace, you know, being happy, right? I've had local executives, because I've been doing this a long time, right? Local executives that all want the same. They all want good things for their members. And they come into it with whole different rhythms of how they want to communicate, right, with the general membership. And sitting down, I've been trained by the RCMP in ADR way back already in 1996, and then taken mediation and advanced mediation. So, you know, on a casual basis, sitting down with local executives and saying, you all want the same thing, and let's put the ideas together, and them coming out and being able to work together really well. So those are easy examples without it affecting your collective agreement that made just the whole workplace a nicer place to be.
Fantastic. Thank you both for joining us tonight. So just so the everyone that's attending tonight, Pam and Jackie will both be sticking around for the Q&A session. So I think we'll move on to our next section of the presentation. So I guess this is the part where I get to kind of ramble for a couple minutes, but basically, what does it look like for, what does ADR look like for separate employers? A lot of my work is with the university sector, primarily the University of Saskatchewan, and you know, they have a process that's quite similar to the federal government. They have people dedicated to this process within their structure. Of course, we have our people we can reach out to, and many people that are familiar with the federal sector know that many departments and agencies do have your own in-house mediator or dispute resolution office, but there are a lot of our separate employers, the smaller ones, that don't have access to this. Some may have the resources to actually maybe bring in a consultant to help out with these situations, but unfortunately, a lot of them are faced with the fact that there's just no mechanism for them to pursue any sort of ADR process, which is quite unfortunate, because I think they might be able to resolve a lot of issues without having to go the grievance process. But unfortunately, they're forced into that. And I'm not saying it's a bad thing to have. The grievance process is something we've fought long and hard to achieve. But sometimes it would be nice, as the examples you've heard, be able to access other mechanisms to maybe achieve a little bit more of a mutually beneficial outcome. So it's just one thing that we wanted to bring up for the group, just to recognize if you're not part of a DCL or a separate employer, that not everyone has those same the access to the same resources that we do at the federal level. So Louise, can we move to the next slide, please? So this is a point where we're going to get a little bit more interactive. We want to talk a little bit about what are some of the fears or maybe the anxiety people might have around the engaging in the ADR process. So we invite you to use the chat function on the side of your screen in that control panel. And please feel free to engage us with any sort of issues you may have, concerns you may have about engaging in the ADR process. So on our slide there, we do have some examples. So one thing that we hear a lot about is maybe the mediator is not qualified, and that maybe if the employer brings in a mediator from outside, a private consultant, it's possible that you may not be feeling that person. You may not be in it's kind of like they always say, if you're going to go to to go see a therapist, maybe you don't actually jive with that person. If you don't have a very good relationship or feel that mediator is really hearing your concerns, you have the ability to step away. People are very much afraid of having that very hostile confrontation, like we talked about in the earlier poll questions about it being a yelling match and that type of thing. This is supposed to be a very controlled atmosphere where everyone has their turn to actually speak together and express their concerns and what's happened. And obviously, if that's not happening for you, again, you have that opportunity to step away. So do we have any coming to? Yes.
Jesse, we have a few responses.
Great.
So for example, one member has indicated that one of the fears might be a term position won't be renewed, AKA out of a job.
Yeah, and I can understand that's a concern. That's a concern that we hear with a lot of our members, and like I work with the academic sector because their contracts are quite short. My contract might not be renewed, or I'm out of a job, and obviously I can understand that concern. But you do have the ability to pursue grievances without the fear of reprisal. So I would think that pursuing an ADR process where you're trying to find a mutually beneficial outcome to a dispute is going to be much more appetizing for your employer or your manager to pursue that, rather than going through grievance processes that could last years.
And Heather has indicated that one of the fears might be a grievance with the manager who has a lot of power over the employee.
As opposed to like the ADR process versus grievances?
Yeah, I guess the fear of going through an ADRs with the manager who has a lot of power over the employee.
Yeah, and I can appreciate again as well. I come from a sector where we have our members that the power dynamic is skewed because you may have in the university sector, you have a manager that's in charge of your academic career as well as your professional career, and people are obviously concerned about raising issues. Again, I think pursuing the ADR process is a much easier pill to swallow than filing grievances. But of course, it depends on the situation. Sometimes, the grievance or the complaint is warranted and it must happen. But I would think that hopefully sitting down with that manager and going through that process would be beneficial. And you may find that actually having that conversation face to face, they're actually maybe on the same page as yourself, and there's just been this the power dynamic sometimes makes them not want to engage in these conversations, and they may even be surprised themselves that they are actually able to have meaningful conversations in the end.
And one of the last ones we have is that this process may be all talk and no action.
Yeah, I think that was actually one of our examples that we came up with, and that's the thing. It's not binding. Everyone can come to an agreement at the end of the process and say, okay, we agree that we're going to communicate in a certain way going forward. we've resolved our issues, we both agree, and they can go back into your old ways, and that is the concern. But it's worth the shot to actually hear each other's concerns and actually hear each other out, and being able to understand the other person's side of the story, which is something that may not come out if you were to follow the grievance process. But again, if it becomes all talk and no action, and you're not seeing any changes, you do have that grievance process available to yourself.
Okay, and I think that's it with what we have in the chat. Thank you.
Great, thanks, Caroline.
Oh, you know what? Sorry, can I just add one last one?
Yeah.
Is the mediator a neutral third party or a designated PSAC officer? That might be just a question which can be answered at the end, or it might be also part of a fear.
I think we'll answer that at the end, because it's kind of a depends question, depending on your situation. So maybe we'll save that one to the end, and we'll let our panelists answer that.
Okay.
All right, thank you. Louise, can we move to the next? Thank you. So I guess this has been covered, but we'll recap a little bit here. So some of the advantages of ADR. It provides your individual grievers that greater involvement with the process. You feel like you have a little bit more control in the outcome, rather than you're kind of at the mercy of of kind of the decisions of management and ultimately adjudication. So mediation gives the parties greater control and flexibility to actively shape the settlements, and I think our presenters have actually touched on that. And really to address the underlying causes in a way that best benefits both parties, rather than being a one-sided kind of win or lose situation. And while mediated settlement might not be achieved, mediation is a potential to clarify the issues and disputes and enhance the parties' understanding of what lies behind the conflict. And I think that's really, it's even if you end up going to grievance in the end, it is beneficial to understand, I guess in a little bit more depth, what the other side's concerns are. So some of the disadvantages, mediation might not be suitable where there is substantial or systemic power imbalances, especially in situations of harassment or abuse or discrimination. And that may speak to one of the concerns that was brought forward by one of the members. And again, I've seen it time and again where some of our members, in this power imbalance, it's just not going to work for them, because they are afraid to, maybe not afraid, but the hesitant to speak up and maybe have that face-to-face conversation with a manager, that has significantly more, perceived power. And I shouldn't say always perceived, but sometimes they like to pretend they have more power than they do. And also one of the disadvantages, because mediation takes place in private, is not tantamount to a private justice system that might not best serve to protect the public interest. And again, like we spoke about, I think Pam touched on this, whereas the outcome of adjudication is, it's public record. So then this could become, something that is beneficial to our other members or other employees going forward. And then the power dynamics of the employment relationship produces a difference in perceptions between grievers and employers regarding the nature and substance of conflict and expectations regarding outcomes of mediation. That's, I guess, yeah, your perception of the issue, as well as your expectations of the outcome. It can be affected from all different aspects of the ADR process, which I'm sure that we can get our panelists to elaborate on here at the end. So I just want to refer you to on your toolbar on the webinar toolbar. There are some handouts for your use. Just click on the handouts and you should be able to download them. Has been past practice with these webinars, they will be linked to the PSAC Prairie's webpage with this recorded webinar. So they'll be there for your to access at any time if you want to download them later and share them with your colleagues. Obviously, when you're in initial stages of some sort of conflict in the workplace, whether it's a colleague, manager, or anyone, or it could be another outside, a third party or something, definitely reaching out to your local stewards or executives. That's definitely your first step. Don't go calling Cheryl's office right away because she would just be overwhelmed. But also speak to your component representatives, your RVPs. That's what they're there for. They're there to help kind of guide through the process. They have a lot of experience, as you've heard from Jackie. She's had tons of experience, and she can point you in the right direction to get things started. And also myself in Saskatoon, Louise as well in Saskatoon, as well as our regional offices across the prairies. We are here to help kind of get you in the right direction with, we can provide further education on these types of topics, as well as we may be able to point you in the right direction as far as a contact, as far as who you should be speaking to within your components. Next slide, please. So I would like to thank you all for being a part of this alternative dispute resolution webinar. I would especially like to thank Louise Mardell, Jackie Maurice, who was part of the development of this, but she couldn't join us tonight, but Keith Gauthier, who's also been in the background helping out, answering questions and helping this move along smoothly. Caroline Klug, who's also in our Winnipeg regional office as our education officer. She was extremely instrumental in helping us develop tonight's webinar, so we couldn't have done it without her. And again, my name is Jesse Todd. I'm a regional rep in Saskatoon. So don't hang up yet, people. We do have the Q&A session coming up next. So I would invite you to use the chat function or the questions function on your toolbar to ask questions, and we'll get our panelists to maybe queue up their webcams and maybe Cheryl just your audio, but we'll get everyone. Oh, there's Cheryl. I think you're muted though.
How's that?
Perfect.
Excellent. Nice to see you.
Good to see you too.
Okay.
So yeah, I guess while we're waiting, we'll just wait for some people to enter some questions, and then Caroline, I think, will shout them out.
Well, we've got our first question, and that was
great.
the question, is
Great.
the mediator a neutral third party or a designated PSAC officer?
I'll jump in if that's okay. In my experience, the mediator is a neutral third party. People tend to refer to me as the mediator, but I'm not. I'm there as a representative of the member. And whether I'm working with board mediators or private mediators, there are neutral third parties that are there, not representing either side, but there to facilitate the process.
Thanks, Cheryl. Is there another one up yet, Caroline?
No, we're hoping and waiting for some more to come in.
So I'll throw one out there for anyone to answer. What do you most like working with the mediation process? Go ahead, Pam.
Well, since primarily every file I get is with the intention that it's possibly going to go to adjudication, I like mediation because I find you can get a better result for all of the parties. And when you go into a hearing, if you're the griever, yes, you will get a chance to get up on the stand, but you're not going to get the opportunity to actually, I suppose, express the way you're really feeling. Like, you're not going to be able to get emotional. Like, it's not as cathartic as I think people think it's going to be. Whereas mediation, when you can sit down, it's informal and you can, get as emotional as you need to be without it being disruptive to the process, I think that's much more helpful. And so that's one of the aspects I really like about mediation, is I find that it actually gives grievers an opportunity to really express how they're feeling and how the employer's actions actually impacted them.
I have to agree with Pam. Absolutely, 100%. The interesting thing about adjudication when I did it, and Pam, you may relate to this, is sometimes when you win, you still don't win, right? That member has been, right? That feeling of they've been absolutely drained of the process, and maybe they got the thing that they wanted, but it doesn't feel like a win. Whereas in mediation, if you're able to find a resolution, even if it isn't everything that the member thought they ever wanted, they got something far less, but because they were able to express themselves, all of a sudden their needs are changed, or they see things differently, or the employer sees them differently, and it's a different level of satisfaction. And it's really an awesome thing to be part of that. I think as a staff of PSAC, Pam, right, it's just an awesome thing to be able to help a member to get that sense of true resolution.
You feel really good when you've walked out of a mediation and you've come to resolution. It feels really good.
Yep.
Jackie, do you want to?
Yes, please.
The sense of your experience?
You bet. I agree 100% because everyone feels like they're part of the solution then, and that they're part of fixing everything in a mediation, where if it's a grievance and you don't win, or even you don't win all of it, you don't feel as satisfied. We're in a mediation and you've all worked together. Everyone seems to come out feeling a lot better with the outcome.
Okay, thank you. We have another question, and this is, how long can mediation take compared to the grievance process, which can often seem like it takes years?
Pam, do you want to start?
Sure. So, I mean, the grievance process, from when a grievance is filed and from when it actually gets scheduled for a hearing, does take years. It can take a really long time. And I guess in terms of mediation, I mean, parties can sort of opt in to mediate at any point, whereas a hearing date is something that the board sets, or or the party set with an arbitrator if we're talking about a private arbitration. But that's something that's set often at a much later date, where you can try and mediate at any time in between. So yeah, I don't know if that answers the question, or if you're looking for how many days mediation takes.
Jackie, do you have any experience with the differences in the process, or?
Geez, you've kind of caught me off guard because I knew that there's somebody trying to ask a question that, and I've texted her and given her the number as well. So I just missed a little bit there. So I'm so sorry.
That's fine. No, like Cheryl, we can move on to you as well. I guess your experiences with the length in the process, what have you noticed? You're kind of nodding as Pam was speaking.
Yeah, no, I agree with Pam also, but so in my job, because I'm approached when it's been referred to adjudication, and from that point, if the parties agree to mediation, we're looking at if I sit down with the mediator and the employer, and we may pick dates within 3 to 4 months. Whereas if that file were to go on to adjudication and eventually reach Pam, for example, that might be another 18 months to 2 years before they're actually going to be scheduled by the board for a hearing, and that's totally out of our control. Mediation is a little, setting dates for mediation is within our control, and we can prioritize, sometimes depending on everybody's schedule, of course, because everybody has to be available, but we can highlight something as a rush or try and get that on. The board has sometimes identified high priority cases, and we can work with the parties again, as long as everybody's available. So, that's a difference of a few months where you can get a resolution now versus having to wait maybe up to 3 years, just because that's the wheels turn that way, and it's frustrating. We're all frustrated by it, but it's it's just how the board works and the backlog that they have that they're dealing with, right?
Yeah, and I just want to add, and 3 years, like 2 to 3 years, is actually pretty optimistic for when it comes to the board. Like, it's it's my experience since I've started at PSCC is the backlog is big, and like I've done grievances that were 10 years old, so
Wow,
there's
I'm back with a comment now. Sorry about that, Jesse, but
that's fine.
in my end of it, when you're dealing with those lengths of time where it's 2, 3, 4 years, right? On my end, I'm dealing with that member on that membership and that local executive that are trying to keep that member calm, right?
Yeah.
It is such a hard thing to do, and they're getting more agitated as days and months and years roll by. Where if you can get into a mediation process, as Cheryl said, that's months versus years. And the boiling point is the time waiting, right? So if we can solve some things with mediation, we're that much better off.
Exactly.
Okay.
Caroline, you have another question?
Yeah, we do. So how does someone initiate the ADR process? Is it through the steward, local president, or other? Is there paperwork like the grievance process? Jackie, maybe you'd like to start the conversation because you have that initial working with the members.
Sure. I've never had any paperwork in front of me, just a request. And I have gone to management with the request. And because I also am a trained mediator, I have the phone numbers to SAS Justice, to the mediation department, right? So I can also go that route and try to work in the background to get something set up quickly. But I will go to the management of the RCMP or Justice or wherever that I'm representing and ask for a mediation to happen.
Cheryl, you have anything to add?
I just had a brain blank. Yeah. I'm gonna skip it because I just
Okay.
forgot my thought. I'm embarrassed, but I just forgot my thought. So
Not
it's
a
okay. I'll
problem.
pass.
Pam, do you have anything to add to Jackie's comments?
I don't, only because I don't usually get involved at the lower level, so I wouldn't have much of an interest.
No, that's fair too. Yeah, because the requests usually happen earlier on. But I guess there's that time, those experiences from time to time where it might land on your desk. You're like, well, maybe mediation. You could suggest it, I suppose, right? But
Oh yeah, and
Yeah.
those, sure, yeah. When it comes to me, mediation is always something that is at the forefront of my mind. Yeah.
Right.
So the next question might be given over to Cheryl or Jackie, and it is, what are some techniques or tools used during mediation to open up communication between members and the employer?
I could jump in. I'll just say a couple things, and I'm sure Jackie will have lots to add. But one of the things that I think is very important, and it's hard for members because sometimes it is emotional, but I think it's be honest about those impacts, right? I always encourage members that the employer is coming to you, and at the point that I'm dealing with them, you're dealing with directors, associate directors, you're dealing with people who may not know you as a member individually. So you want to really humanize your experience. You don't want it to be, file number 52683 and what they've read from labor relations and what their impression of you is. Give the words about you a human experience and be honest. And if you're honest and open, and yes, sometimes that means vulnerable about particular issues, I think if you're honest and you share that perspective, it can be very impactful, right? So it's not a fancy tool, it's just approach it honestly and with an open mind. And I think that's an important tool to have in mediation from the perspective of members I work with. Jackie, you may want to add to that.
Absolutely. I'm very honest with them and talk about different things in my life where I've used mediation actually, and it makes them feel more comfortable about the mediation process. I've talked about the fact, I divorced 20 years ago and I went through the mediation process then, and how we came out of that, enjoying and using that process, right? And talking about the common goals, that would probably be one of the most important things, is when you're talking to these people, getting them to realize that there's common goals, right? And I think that that really makes the process work well, is if you show them together that you may have the same common goal, and that makes them more receptive to the whole mediation process.
Yeah.
Okay, that's it for our questions.
Okay, well, that's actually a good point. I guess we can probably look at ending it
Sorry,
here.
Jesse.
Yes?
One last question that just snuck under.
One last question, go for it.
If everybody's agreeable, are there costs, and wouldn't managers be shy to pay out of budgets?
Well, can I respond to that one, actually?
Absolutely. Yep.
Most of the time I go into it and try to tell management, and they're usually in agreement with the fact that it costs them less to mediate it than to deal with having these employees that aren't getting along. Managers are spending far more time dealing with the disruptions in the workplace. Grievance processes have costs to them as well, right? They have huge costs. So if you weigh that out to them and discuss with them the fact that mediation does have a cost, but the grievance process has a cost too. So that's something that I use as a tool, is that everything has a cost, but what will fix it sooner, what has everyone more productive and a happier, healthier workplace.
Cheryl or Pam, did you want to add anything?
I have to agree with Jackie. Absolutely. Yeah, that's all I have to add. Go ahead, Pam.
No, I'm sorry. I thought I had my phone on Do Not Disturb. It started ringing. What the heck is going on? Yeah, I mean, there's the cost benefit analysis, and I think that overall mediation is probably the more cost efficient method as opposed to arbitration, because arbitration or adjudication may not, you may have 4 days set for hearing and it could go on for 10 or even longer. So.
And if I could just add, in the federal government, if we're dealing with our federal government members, there's no cost to mediation, going to mediation, the work that I do, that Pam does, because the board is there. It's a service that's offered to the parties in the collective agreements. But there is a cost in terms of time, managers' time and preparing, and that's associated with adjudication, even though they're not paying for it. So even in the situations where I totally understand the cost benefit analysis, as I said, I agreed with Jackie, but even in the case where there isn't a dollars and cents cost, there's a cost in other ways that also is a cost benefit analysis that weighs in favor of mediation.
Great. Well, thank you all for joining us. I'd like to thank our panelists.
Jesse, it's Marianne.
Oh, okay, Marianne, go ahead.
Can I ask a question?
Maybe.
I've been listening intently. No,
All right, go ahead.
please. So one thing that I was wondering, like, I know a lot of departments actually have like ADR officers or offices. So I think, like, the question about how do you initiate it, I think that some departments already have that structure, and I'm assuming that based on what Jackie said, her department actually, it's a formal structure within the department. That was just information on my question. So my question is, though, so if you are going into the ADR process, should you be filing a grievance to protect your timelines? But also secondary, are mediations subject to non-disclosure agreements? And if they are, if say you come to a resolution, but they don't keep their promises, basically, can you then file a grievance, and can you use if there's an NDA? Big question. I've been talking to a lot of lawyers lately, so I got all kinds of questions.
I mean, I'll just the NDA part. Oftentimes when settlements are reached in mediation, or even outside of the mediation process. They're not usually, not, at least in my experience, they're not non-disclosure agreements. They're memorandums of settlement or settlement agreements. So often, because I mean, there's a difference. A settlement agreement usually means that what you're required to do is keep the contents of the settlement confidential. So if you had a grievance and you settled it, you know, and somebody came up to you later and asked, like, oh, hey, whatever happened with that grievance? You can say, well, we settled it. And they say, well, oh, how much did you get? Or did you get all your days back? Anything like that, that has to be kept confidential. Non-disclosure agreements, that's kind of, I think, entering the territory of where, and, you know, oftentimes, especially recently, we hear about non-disclosure agreements in the cases of like sexual harassment, right? In the context of the Me Too movement, where you're not allowed to even speak about the experiences that you had or the sort of nature of the allegations you may have had towards another party. And I've not come across a non-disclosure agreement. In my experience, they tend to be the other, or the former, the settlement. Yeah. Settlement agreement.
Can I speak to just answer to the piece, Marianne, that you said about if they don't, and I'm assuming you meant if the employer doesn't adhere to their sort of agreement within the memorandum of settlement, if there's anything that you can do. I haven't done it, but I don't know if it's a grievance that you would file. Pam, maybe you can help me with this, but you would definitely have a recourse to enforce that settlement, right? It's a document signed by usually someone who has the authority to bind the department, the employer, Treasury Board, whoever it is. So there is recourse to hold the employer to, you know, to their undertakings in that agreement, and vice versa. You know, sometimes there is, yeah, as Pam said, a confidentiality aspect of the settlement itself. And sometimes, you know, grievers are warned that, you know, if that person comes up to you and says, hey, whatever happened to your grievance? And they say, yes, I got $50,000. Sometimes that money can be taken back, right? And so there's an obligation on their part too to do their part. But in terms of the employer, we can definitely hold them to account if they break the elements of the the settlement. And oftentimes we won't withdraw the grievance until they've done certain elements of the settlement. We do that to protect the members, because I've been here for a while, so we've been burned in the past. So now it's actually a policy where, right, Pam, we're not allowed to withdraw until certain elements have been implemented.
Yeah, and usually that,
And,
I mean, oh yeah, sorry, go.
So go ahead.
And usually one of the clauses that, I mean, the employer just by standard now includes this, but like that's a clause that we always have, make sure is in any memorandum of settlement, is that the grievance, the union will not withdraw the grievance until the terms of the settlement have been fully implemented. And that's for that reason right there. And I mean, really, you're entering into a contract, right? This is a contract between two parties, so it is enforceable. Yeah.
And it could take years, because especially if you've got files that involve anything to do with Phoenix, even though we've now got people who are helping to fast track those Phoenix related settlements. And our position is it doesn't get withdrawn, you know, because they like to say, oh, Phoenix is not our problem. Well, yes, it is. You're the employer, fix it, find a way to pay. And once you pay or do the things that you're supposed to do, then we'll withdraw it. So we really don't play with that at all.
All right. Well, thank you very much to our panelists for joining us tonight. Thank you, Cheryl, Jackie, and Pamela. You guys, you know, helped a lot with this topic, and you know, shared a lot of knowledge with us tonight. So thank you very much for joining. So I guess that brings us to our closing remarks. So I will let Marianne close things off for us.
Perfect, thank you. And I promise not to ask any more questions, but thank you so much to our panelists. You know, I think sometimes, you know, I've met Pam because she's in Calgary. I heard Cheryl's name and I'm like, I have no idea who this is. All I know is that we have a fabulous crew in our G&A section, but in my position, I don't deal directly on grievances. That's what the component. So so I want to thank you for joining us this evening, and Jackie, of course. We go way back, but we're not going to go there because this is being recorded, so we're not going to talk karaoke. Just saying. But I do want to thank you, and you know, as I said when we opened, we've been doing this whole series of webinars, and honestly, I don't think any of us truly has figured out uh, where we're going to be in the fall with our education schedule. We don't know if we'll be able to do in-person training, but I do appreciate any feedback that you want to give on the webinars. If there's topics, absolutely the ultimate best way to learn is in a room together where you can interact and spend time together, but that's just not possible. And through the assistance with the staff, and all of the guests that we've been getting in, I had someone tell me last night, that's the most education we've got in years. And it doesn't replace a whole weekend course, but I just want to say, as we're closing the webinars for the summer, we'll see what we do over the summer, but we know it's a short time in the prairie, so people take advantage of that. And depending what's happening, we may relaunch a whole series in the fall. So any feedback that you want to give on topics, on how things worked, any suggestions, we're absolutely open, because at the end of the day, this is for the members, and I said it from the very first one. The one thing that I miss the absolute most in all my 20 years, I have never gone this long without talking to members, without being able to go to an AGM, to be able to go to an area council meeting, to get on the road and stop at workplaces. So, this gives me a little bit of a chance to connect with people. And I truly do appreciate all of our members who have been spending their evenings with us and, providing some feedback. So, to everyone, thank you. And have a great summer. Stay safe. And please know that your union is, we're there for you. We're in this together. So if there's something you need, go to prairies.psac.com. My email's on there. I think my cell phone's on there. If not, everybody's got it. And please let us know. We will connect you up with who we need to connect you up with. And, not sure, but for our Treasury Board folks, we're at the bargaining table right now. So if you've not sent your email to the president of the Treasury Board, now would be a really good time to do that. So we may be spending time together on ratifications if anything develops. If not, we're going to need to work together in a different way to be able to get collective agreements for our federal members. But overall, thank you, everyone, and have a great summer. And again, to you and your family, stay safe, and we'll talk to you in the fall for sure.
Thanks, Marianne, and thanks to our panelists and all of our staff that work behind the scenes tonight. And of course, we appreciate all the people that attended tonight. So have a great evening and enjoy your summer. Good night.
Good night.
All right, bye.